Thank you, George. I appreciate the opportunity to be here today and talk to all of you about some of the basics associated with recognizing the characteristics of your land, the ownership of your land, a little bit about estate planning for the future, and other types of planning that are really necessary to knowing what your future entails and what will happen to your property. So the first thing I'd like to do is go through a self-evaluation process, things that you need to know before you start planning. One thing that everybody thinks they already know is who owns the land. Yeah, it's silly, I own the land. Well, do you have a deed that has your name on it? If you do, you own the land. But sometimes we don't have deeds. Sometimes we have an inherited piece of property. And you say, well, my daddy had it, my granddaddy had it, my great-granddaddy had it. Well, if all three of those people died intestate, there may be 47,000 heirs out there, and each one of them has a little piece of your property. So it's important to know that. Review your deed. There are 2 deeds in the materials that just kind of go through the sections of the deed and what they mean. Review any mortgages or other security agreements that are on the property. If you have borrowed money or someone else has borrowed money and pledged your property as a security interest, there should be a mortgage or a deed of trust on that property. And that is, a public record. And you should be able to access that and see it in the county records office in which the land sits. You should also review any estates or wills by which your property was received. So if you inherited it, make sure that the will said that you inherited it. Make sure that you have a deed of distribution from the personal representative or the executor of the estate, if that was required. If it was before that was required, that it is included, that piece of property described is included in the probate file of the person who owned the property at death. The person or entity whose name is on the deed is the legal owner of the property. So if it is your name, then you are the legal owner of the property. If it is your name as trustee for, then a trust owns the property. If it is a corporation, then a corporation owns the property. Now you may have beneficial interest in any of those things, but the name on the deed is the actual entity that owns the property. Just because you live there doesn't mean that you're the owner. South Carolina in particular has a huge amount of property that is heirs property. It was inherited by several generations of people, and everyone has built a house there. There may be 1,000 acres of land, and everybody has built a little house on there through the generation. And you may each have 135th interest in it, 135th interest. Curing those problems can be extremely expensive, time-consuming, and sometimes you can't do it. And you need to recognize that and know what you're dealing with. Is this property that is yours, is it your primary residence? If it is your primary residence, do you get all of the tax benefits that are associated with having that as your primary residence? Do you get a homestead exemption? Is your property classified as agricultural? Do you get the lower tax rate because it is in agricultural use? Make sure that your county assessor has an accurate description of your property. Make sure that the acreage comports with what you think you have, and that there is a little description on there, whether it's a tax map number, whether it's a lot and block number. Make sure that the description on the tax assessor's records comports with your understanding of what the description is that you have. If you're being taxed on 217 acres, but you only own 200, something's wrong. You need to find out what that is and why it is that the assessor's office believes that you have more property than you thought you had. Sometimes there are inholdings in property. You may not know that in your 100-acre parcel there's a little 1-acre piece that somebody else owned and reserved out when the grant of the 100 acres was made 50 years ago. So these things are important to know. If you don't have copies of these documents affecting title to your property, get them. They are all recorded in the Public Records Office. They are required to be recorded in the Public Records Office or filed in the Public Records Office in the county in which the property sits in order to give notice. Anyone in the world has constructive notice, meaning they're supposed to know it's there if it's recorded. And if there are any unrecorded documents that affect the title to your property that make it clear that you own it, make it clear that a mortgage is paid off or a deed of trust is canceled, quitclaim deed that conveys back that interest that a deed of trust conveys out, make sure that those documents have been recorded. If you have a loan, you've paid off the loan, the lender has the obligation to record that. Sometimes they don't do it, but they will send you the satisfied note and mortgage, and you can do it yourself. Check again the county tax assessor's office for description and classification information. Make sure you're getting the tax benefits you're entitled to. Look at your deed. If you have a deed to property and it describes 217 acres lying in Pickens County, in Bennett Springs Township, well, that's not too much information to go on. But check the legal description on the deed and make sure that comports with what you think you own. If it says this property is 217 acres in Pickens County in Bennett Township, and it describes lines all the way around the property, that's great. But more often than not, it's 217 acres lying or being in Bennett Township, Pickens County, bounded on the north by lands now or formerly of Smith, on the east now or formerly Jones, on the west by Highway number 2, and on the south by other lands of the grantor. And sometimes that doesn't help you too much. So if you have doubts about whether the legal description adequately describes your property, now is probably a good time to get a surveyor to go out and survey your property, to actually see where the lines lie on the ground. Because no attorney can draft a legal description that's going to tell you where the lines are, where the trees are marked, or the corner pins are set. Nobody can tell you that unless you go out and look at them. There are probably plats or surveys recorded, again, in the Public Records Office that may be pictures of your property. Get those. Make sure you have a file. In your management file where you have management plans and information about your timber sales and information about what you're planting and what you intend to do, have a little file in there about your property, the legal description of your property, the ownership documents, anything that relates at all to your property. Obtain any judgments or any court action concerning title to your property. If it occurred before you came to own it, it may still affect your property, so you need to know that. For example, I had a client who had 2 lots next to each other in rural Allendale County, and one of them was inherited from this man's grandfather. The other one was inherited from the great-grandfather. Both of them died intestate. Both of them had 9 children. So, did he own it? No, he didn't own it. We have to do something about that to get the ownership in him. But I was told there was a court action in 1926 that did eliminate some of these problems, but the Allendale County Courthouse had burned and all of those records were across the street in boxes in a trailer. So, you know, it would take a substantial amount of time to go over there and dig through the boxes, and we haven't done that yet. But those are things that you need to know. If there is a possibility of finding a court judgment that settles the issue of ownership of some of your property, that's probably worth you going and digging through the boxes to find it. Know the identity of any person who claims or could claim a legal or equitable interest in your property. A legal interest is one where the name is on the deed, the name is on the judgment. There is somebody who has some kind of legal interest in your property.